Thank you very much. Actually, this is the second time that I've had to follow Professor Shabbos, so we're going from the logical to the fairy tale. Because what I'm about to say, I've said so many times now, few people actually believe it's true until they actually start to look at what we're doing. It's quite right that I came very close to entering Bangladesh quite recently, and I was stopped at the border, questioned as to why I was there, and when it was clear that I was there to represent my clients, I was held for 10 hours and then thrown out of the country and sent to Dubai. Every cloud has a silver lining, obviously. So I was in Dubai for several days, trying to rearrange the visa situation. Unfortunately, that was never going to happen. This is what we've come to call the International Crimes Tribunal. Actually, Stephen coined the phrase, a wolf in sheep's clothing. And it really is a wolf in sheep's clothing. Greg, what you said, I've now reached the highest accolade of an international criminal defense lawyer by being reported to the Bar Standards Board along with John and Stephen as a result of our criticism of the Bangladesh Tribunal. I'd like to look at this first. This is the Bangladesh government's statement of intent, and this was by the Prime Minister in her address to the UN General Assembly in 2010. This statement really epitomises the dishonest attempt by the government to convince the rest of the world, the international community who's watching, that this is an honest attempt to address a very painful part of their history. And it should be stated at the outset that it was an extremely painful part of their history, and no one is denying that. Crimes were committed on a gross scale, possibly not seen in many parts of the world. We've consistently made it clear that it is now our role to stop these cases going forward. It's our role to minimise the level of victimisation. We've made it clear that Bangladesh is under an obligation under international law to bring an end to impunity, but is also under an obligation to do it properly. And I have to say that all the criticism that Stephen, John and myself have faced has been as a result of asking the government to do this properly. We haven't unfairly criticised any player in this process. We haven't undermined the credibility of Bangladesh as a nation or the International Crimes Tribunal. We've merely tried to get them to accept what their obligations under international law actually are. And as you can see, the Prime Minister in 2010 stated this action is in accord with the rule of law as reflected in the Rome Statute of the International Criminal Court. Well, quite simply, it is not. And it is not in a number of respects, which I'll go through now. So if we look at, first of all, just a brief history of what we're actually considering. First of all, whenever we start to speak about this, the first question everybody asks is, well, what war? There has been a war for 40 years. Well, that's the point. We're looking at the War of Liberation of 1971. Immediately following the cessation of hostilities, a number of individuals, and the first thing that we need to look at was the intention in 1973 of what the newly created state that Bangladesh was trying to address. And what it was trying to address was 195 Pakistani prisoners of war, military personnel who were in the custody of Bangladesh, who were to face trial. So an International Crimes Tribunal Act was enacted in 1973. this was legislation for a military tribunal, not a civilian tribunal. This was a tribunal to prosecute members of a military force from a foreign state, not citizens of Bangladesh. We then had, shortly thereafter, the first constitutional amendment. Now, the first constitutional amendment is possibly one of the most offensive pieces of legislation you're likely to see, because it directs a removal of rights for anyone accused of war crimes. Two provisions within the first constitutional amendment strips accused of their fundamental rights guaranteed under the Constitution. Rights that we will take for granted. Rights as lawyers that we fully expect to receive. Now, I know that our government is trying to strip our proceedings of certain rights, but this first constitutional amendment strips all rights that an accused is likely to have to receive a fair trial. The next point is the Presidential Decree number 16 of 1974. This piece of legislation gives immunity to anyone who fought on the side of the liberation forces. So that effectively means that only those who fought on the other side will ever be prosecuted. Now, on one of the occasions when I was actually allowed into Bangladesh, I actually made this point in a seminar, that this signifies that the legislation is discriminatory in intent. And if Bangladesh wants to do this properly, it has to be applied across the board. Now, I wasn't suggesting that any member of the liberation forces, and I wasn't aware that I was actually in a meeting with the commanders of the liberation forces, I was not suggesting that any of these individuals had committed a crime, but to remove the discretion from the prosecutor from looking at matters committed by both sides indicated that this whole process was fundamentally wrong. We have been called many, many names for making those arguments. Stephen first made it when the two of us went to Bangladesh in October of last year. I've made it on at least two occasions. John has made that point in two separate addresses, one in the US and one at Oxford University. And we can all give you the experiences what we have received in terms of the audience, the personal attacks, the professional attacks that have now culminated in reports to the Bar Standards Board. We then have a situation where 195 soldiers in the custody of Bangladesh are returned to Pakistan under the tripartite agreement. This is a peace agreement, an amnesty for anyone accused of war crimes from 1971. The 195 soldiers are handed over to Pakistan on the undertaking that Pakistan will prosecute them through their own judicial system. This, of course, never happened. Nothing happened until 2009. And in 2009, there was an International Crimes Tribunal Amendment Act that the current Awami League government enacted in order for the tribunal to be created. And it was created in March 2010. March 2010, for those, March is a very, very significant time in terms of important dates for Bangladesh. March and December, much happens with this tribunal in March and December, because these are significant dates in terms of their liberation and their establishment as a sovereign state. The tribunal is created. The judges, prosecutors, and investigators are all appointed by the government. There has been much criticism as to the control over these individuals by the government. In particular, the government gave a very proud declaration 2 days ago that the Prime Minister and her internal cabinet had met with prosecutors for a briefing. Didn't seem to think that there was anything wrong with this. Ministers frequently dictate the timeline of these cases for when people will be arrested, for when trials will start. A prosecutor recently really assisted us because we were running in the dark as to whether things were going to proceed. And one of the prosecutors gave a public statement determining when the trials would start, when the accused would be convicted, and when the executions would take place. So at least we're not in the dark anymore. One of the main criticisms we've made is that this is not a legitimate tribunal. This is political retribution. Now, whether that is true or not, the government is not helping itself by only targeting members of the political opposition. 7 individuals currently stand accused, and when I say accused, only one person is being charged, despite being in custody for 18 months. These 7 individuals are the only targets, and they are all members of the 2 main political opposition parties. Now, there's been widespread criticism. The government has tried to suggest that this is a fair process. They argue the accused have a right to appeal after conviction, so it's fairer than Nuremberg. We've tried to explain that we've moved on substantially since Nuremberg, but that seems to fall on deaf ears. So, in order to address some of these concerns, they invited the US War Crimes Ambassador, Stephen Rapp, to Bangladesh in January of this year to conduct an assessment. He made an assessment, rather weak in our view, but he at least made some recommendations for change, all of which have been largely ignored. The government will try to convince the outside world that all of these recommendations have been implemented, but they have not. For example, there is no right to interlocutory appeal. There is no right to challenge the jurisdiction of the tribunal or the appointment of any judge. The way that the tribunal has tried to fix this shortcoming is to allow the judges, the same judges, to review their own decisions. We have no right to petition a higher court to challenge any decision of that tribunal, only to request the same judges review their own decisions. The 15th Constitutional Amendment merely extends the first Constitutional Amendment, whereas the first Constitutional Amendment primarily focused on the rights of military and auxiliary forces. The 15th Constitutional Amendment now covers everyone. So anyone accused of war crimes for this tribunal now has their rights excluded. And when the 15th Constitutional Amendment was adopted, the law minister, the equivalent to the Minister of Justice, proclaimed proudly that the tribunal now has constitutional protection. There can be no challenge to the tribunal. And he made this declaration public. The first trial is expected to start during the month of November. Now, to see how the first trial starting raises a number of concerns, it is important to point out the process that we've gone through in order to get there. Over the course of the last 6 weeks, the prosecution has drafted charges, none of which we were able to have any advance notice of. The tribunal has accepted those charges because the system in Bangladesh is the judges who issue the charges. And then there's a form of confirmation hearing. Nothing that Stephen has spoken about, because a confirmation hearing in Bangladesh is I'm going to read you the 20 charges and you are going to enter things you're not guilty of. That is a confirmation hearing. The accused had literally 5 minutes to consider whether he wanted to plead guilty or not guilty. When his lawyer, a Bangladeshi counsel, rose to his feet to ask if he could advise his client, he was told, this is not a matter for counsel. This is between the judges and the defendant. You have no right to advise them. That is particularly egregious when one considers that the investigation is conducted in a shroud of secrecy. We have no access to the investigative file as the investigation is proceeding. I can tell you it's a shroud of secrecy because when I attended the tribunal on one of the occasions I was allowed in, and I discussed this with one of the judges in a general sense, I was told, well, we can't give it to the defence because they don't know what we're doing. That would make it so much more difficult for the investigators. Didn't seem to think there was anything wrong with that. We then had an interrogation of the suspects. We filed a lengthy petition requesting full disclosure and for counsel to be present during interrogation. Once again, we were told, well, how possibly can counsel be in interrogation? He'll tell the suspect what to say. It will be so much more difficult for our investigators. So we were not allowed to be present during the interrogation. We were allowed to be in the same building. We were about 25 metres away. We couldn't see anything. We couldn't see the room. We had no idea who was conducting the interrogation. But we were at least allowed to see the client for 30 seconds before he went in, even though we were told we couldn't say anything to him. So we could give him no advice. The only advice we could possibly give was say nothing. And that was the procedure that we had to adopt. Unfortunately, that doesn't really help when the investigators go out halfway through the day to the way to the media and tell them that our client just confessed to genocide. So these are some of the difficulties we're facing. So, the government's response. Trials will be upheld to the highest international standards. This was in an interview by the Foreign Minister to the BBC in the beginning of 2010. The most interesting statement is by the State Minister for Law. The tribunal will be a model for the world. The tribunal is a defence charter. This is what the registrar said when he attended a conference in London. There is a distinction between the rights of ordinary citizens and the rights of war criminals. This is a Supreme Court justice. When we suggested that the first constitutional amendment should be amended, the response was these men killed and raped throughout our country. And the list goes on. Interestingly, you can see towards the end, the tribunal will uphold international standards of fairness and due process. Later on, the tribunal is not bound by international standards. The tribunal is an international court. Later on, the tribunal is not an international court. So whenever they're confronted with stark criticism, they backtrack, they change the position. So here are the main criticisms. First of all domestic laws, the Criminal Procedure Act and the Criminal Evidence Act, are explicitly excluded from these proceedings. International law is excluded. Whenever we have attempted to raise issues of international law under the International Covenant on Civil and Political Rights, or the statute of the ICC and the Rules of Procedure, because it shouldn't be forgotten that Bangladesh is a state party to the ICC. Since October of last year, they very proudly proclaimed themselves to be the first Southeast Asian state party. No jurisdictional challenge permitted. Constitutional protection of fundamental rights removed. No rules of evidence. No privileged communications. When our clients, or when our Bangladeshi counsel meets with a lay client as they are all in custody, they sit at a table with an intelligence officer or a prison officer, just in case we discuss anything related to the case. Foreign counsel thrown out of the country. That's me. The three of us barred from re-entering. Any form of criticism is curtailed by contempt allegations and sedition charges. The only individual who we can say is perceivably independently reporting on these proceedings is a British journalist in Dhaka. He has consistently criticised more progressively over the last 3 months the conduct of the tribunal. When I was in Dhaka in May, and I was observing the proceedings, this journalist, David Bergman, was in court. He was told to stand up by the 3 judges. And they read out a segment of one of his most recent news stories. And each of the 3 judges in turn criticised him, threatened him with contempt, and said, had it not been for the fact that you're a foreigner, you would be charged with contempt today. This was not a message to him. It was a message to the 30 or 40 Bangladesh journalists who were in the room. He probably should have paid more attention to that criticism, because tomorrow, I believe, he has been summoned to appear before the tribunal on contempt charges. To him, his news agency, and the publishers. We've already said that the government dictates the timing of the proceedings. And one of the main reasons for this, it shouldn't be forgotten that the Awami League government came into power with a sweeping majority in 2009. This was largely on the pledge to hold those responsible 1971 accountable. This is the rhetoric that they've used since 2009. This is what got them elected. And this is the only thing internally that perceivably they have not failed on, because they've failed on every other election pledge. This is why this is so important. They will not allow the tribunal to fail. The intention is to convict a handful of these individuals who will all be sentenced to death, because that is the ultimate penalty. We learned today, which I only learned just a short while ago, the minimum penalty is actually 10 years. The maximum is the death penalty. Then we look at one of the most recent criticisms that we've made. This really shows how serious the tribunal is in their conduct. The chairman of the tribunal was a member of a commission of inquiry in 1993 that conducted investigations into these cases. These cases focused on a number of individuals, including our clients. The commission held mock trials. They were convicted, and death sentences were passed. Effigies were burnt to signify they'd been sentenced to death. The chairman of the tribunal was a member of the secretariat of that commission. We have sought his refusal. It was refused. It was refused on the basis the chairman excused himself from the discussion, and the 2 wing judges concluded that the law as it currently stands does not allow them to refuse a judge, or to force the refusal of a judge. We have cited examples from the international tribunals. We have cited the example of the Pinochet case with North Africa. And their response to that was, whilst foreign jurisdictions have the benefit of such a practice, we do not. So we cannot. So we leave it to the good conscience of the judge. Unfortunately, the judge remains. We will find out tomorrow whether he has continued to sit, but he has certainly sat on a subsequent hearing following the refusal application. The 3 of us, Foreign Counsel, wrote to the judge recommending, in the interest of justice, that he refuses himself. That is what we now stand accused of. That is misconduct in their eyes. And to put it in the wider context, it's not just us. The government will say that there has been widespread support for what they're doing. And that is true to a certain extent. There's widespread support for the initiative to set up a tribunal. There is absolutely no support for the way in which they're doing it. And all of these institutions bear testimony to that fact. They have all widely criticised, recommended change. No change has been forthcoming. As I said, the US Ambassador at Large for War Crimes has focused on a number of procedural protections that need to be amended and have been flatly ignored. The International Bar Association War Crimes Committee was one of the first institutions to set out a list of key problems within the legislation. Amnesty has focused primarily on allegations of torture of one of the suspects. Now, this is something also important to note. One of the accused, by the name of S.Q. Chowdhury, a member of the Bangladesh National Party, was arrested in circumstances unrelated to the war crimes allegations. He was held for 24 hours, and then he was brought before the tribunal. Or, effectively, his case was brought before the tribunal. He was not. He alleged that he had been tortured in police custody. Now, I'm not saying whether that's true or not, because I don't know. Because we have been unable to get a doctor into interceding to assess whether he has injuries. The matter has been raised on 3 separate occasions with the tribunal. No investigation has been initiated. What was initiated was, and a 3-member investigative team was appointed to investigate how he sent a letter to the British Foreign Office detailing his torture allegations, but no investigation to the torture allegations themselves. His case is also particularly interesting because he is refusing to accept the jurisdiction of the tribunal. He is refusing to appoint a lawyer. So the tribunal now proceeds in his absence. Charges were put before the tribunal several days ago, and he was not produced. The hearing was held in chambers because he has no lawyer, despite the fact there's a very clear rule that allows an individual to represent himself and also empowers the tribunal to appoint the lawyer that he does not have for himself. None of this has been done. Human Rights Watch has focused on another area of concern. Quite recently, a press statement was issued by Human Rights Watch in The Hague because of attempts to intimidate the defence. Now, throwing me out of the country and accusing us of misconduct is a form of intimidation. It is that we become too fearful to represent our clients. And that's where we, of course, have to act courageously. But the lawyers in Bangladesh have to be all the more so. There are specific incidents of at least one of our counsel being threatened with arrest. Interestingly, he was, according to the government, he was demonstrating on the streets of Dhaka on the 19th of September of this year. Luckily for him, he was in my presence at the International Criminal Court at the time he was allegedly on the streets of Dhaka. So he has a fairly good alibi because he was with the registrar of the International Criminal Court. And as appalling as that meeting was, I think she will remember us sitting in the room because she tried to solicit funds from Bangladesh for the fund of the International Criminal Court. So I think she will remember actually meeting us. He has been threatened with arrest. Diplomatic pressure has been such that that threat has not been executed, but it is ever present. Another one of the defence team, effectively our trial lawyer, and we have to use junior lawyers because the senior members of the bar will not put their name to this institution because they do not want to give it any credibility. So we have junior members who are doing an admirable job with our assistance. One of those lawyers has been threatened not only with arrest, but with attack on himself and members of his family. We have defence witnesses who have been intimidated, who have been arrested, who have been threatened with false charges if they continue to give evidence for the defence. This is the atmosphere that we are required to operate under. Our investigator has now been arrested. He's a journalist, and he has been arrested for having participated in demonstrations as well. Our key witness has been arrested. Now, he was a freedom fighter for the Liberation Forces in 1971, so he has no axe to grind. He is giving this because he believes the first accused had no participation in these crimes. And it's also important for a moment to consider what these individuals, as far as we're aware, with the fair information we have, what they are actually accused of. Largely, they're not accused of having committed murder, rape, torture, plunder. They are accused of having collaborated with the Pakistani forces. They're being charged with crimes against humanity and genocide. But if you look at the legislation, you'll see that this is the most appalling definition you're likely to see. Much of what we've heard from Professor Shaba, it would be nice if the government of Bangladesh listens to that and understands the meaning of crimes against humanity, because it would appear that the tribunal doesn't really understand that. And just to explain, in one previous hearing, one of the judges asked the prosecutor, "Here, Mr. Prosecutor, you've charged 18 counts of crimes against humanity and 2 counts of genocide. Where lies the distinction?" Well, Mr. Judge, if it's one incident, it's a crime against humanity, and if it's more than one, it's genocide. That is the level of sophistication in terms of their charging. These are largely not crimes against humanity. These are incidents that should have been charged under the domestic legal order, through their domestic legislation. There was an act after the conflict, which was the Collaborators Act. That was intended to deal with many of these cases. It never proceeded. So, Stephen has asked me to title this a journey in search of fairness, and I can tell you it is a journey. We've had the fortune or misfortune of being in Bangladesh together, working with our Bangladeshi lawyers, trying to prepare them for the trial. And we've had to do things that a barrister is not necessarily trained to do. Because it's not just the legal work. It's the lobbying work which is absolutely essential to this type of case. We cannot separate law from politics in a case such as this. All war crimes cases are political by their very nature. This more so than any other case. So, how do you lobby in favour of your clients? Well, there are many different organs that you need to approach. International organs, human rights monitoring bodies. We are trying to ensure that the trials are monitored by a reputable international organisation. We have approached Amnesty, Human Rights Watch, the International Centre for Transitional Justice, and we've also approached the OSCE in Vienna. All of these institutions are keen to monitor the trials, but all of them have to have an invitation from the government, and that's unlikely to happen. We have filed complaints, petitions with various special rapporteurs. The Special Rapporteur for Torture, for independence of judges and prosecutors, arbitrary detention, and the Human Rights Council generally with a general complaint as to the overall circumstances of this case. We have prompted parliamentary bodies to have debates and discussions on this very issue. It's important to note that the United Kingdom is one of the largest donors to Bangladesh. One thing that may have escaped many people, is that we are giving over £1 billion in unconditional aid to Bangladesh, which is a good thing, provided we are satisfied that that money is going where it should go, that it's not going to fund a judicial system that we are looking at today. One of the areas of criticism of the United Kingdom very, very recently was that our police were training the Rapid Action Battalion, which is a special unit set up to deal with counter-terrorism in Bangladesh, were training them on human rights standards. There has been several hundred disappearances over the last couple of years in Bangladesh. There has been numerous allegations of torture. 2 defence counsel in particular have died in police custody. That's why we need to address this government to ensure that that money is going to support proper development in Bangladesh and not supporting a system that has total disregard for human rights. We have done the same with the European Commission and the European Parliament, because the European Union is a major donor to Bangladesh. The European Union needs to be satisfied that it is supporting a system that has respect for human rights. The death penalty is a particular issue in the European Union. It doesn't like to engage in a state that has the death penalty. Very little has been done to change that. The government of Bangladesh has basically said that is non-negotiable. We are not going to remove the death penalty. The Council of Europe has also taken this forward. So, a model for the future? I certainly hope not. Politically selected targets for prosecution, no independence, no objective impartiality, investigations conducted under a cloud of secrecy, suppression of media, interrogations conducted in secret, widespread allegations of ill treatment of detainees, no privileged communication, foreign counsel prevented from entering the country, and defence lawyers and witnesses subject to threats of false arrest and intimidation. I will agree in my conclusion with the statements of Lord Cameron Islam. This is a model for the future. This is something that the international community needs to look at, because this is a very, very good example of what not to do. Thank you.